Good evening, everyone. My name is John Paul Cody-Cox, and I'm the Chief Executive Officer at the Canadian Physiotherapy Association. I will be moderating today's 30-minute session. During today's session, we will be discussing the current state with COVID-19, tele-rehab, and business interruption insurance. You will hear brief statements from BMS Canada Risk Services, Gowling WLG, on this topic. Following that, I will be asking BMS and Gowling questions that we have received from our members over the past few days. Please note, we will not be taking questions live from attendees during this webinar. However, at the end of the session, I will share more information on who to contact with additional questions. In addition, we will be recording today's webinar and it will be made available on CPA's channels. I would now like to introduce our speakers. Brian Gomes is President and CEO of BMS Canada Risk Services, a specialist insurance brokerage that works exclusively with CPA and more than 70 associations and member-driven organizations across the country. BMS's liability programs are focused on delivering significantly enhanced association and member value, comprehensive products through sophisticated technology, improved service, and data-driven risk management. Andrew McKenna is a partner in Gowling, Ottawa's office. Andrew's practice focuses on medical defense litigation and health law. As counsel for physicians and other healthcare professionals in both civil and regulatory matters, Andrew has appeared in all levels of court in Ontario, as well as in discipline committee matters, hospital board proceedings, and before various other administrative tribunals. I will now turn the session over to Brian and Andrew.
Thank you, JP, and for everyone's time tonight to run through the webinar on what is becoming increasingly an extremely important topic from a multitude of perspectives. This certainly is an unprecedented and ever-evolving situation, and at every moment there are situations arising and questions being posed that the insurance industry has never faced. There are definitions and policy wordings that are and will be challenged in ways that have never happened before, through claims being put forward and ultimately challenged in the courts that will set new precedent into the future. Our volume in the past 48 hours has exceeded what we would typically receive in a 2 to 3 week span from our clients in both emails and calls. So we appreciate all of the inquiries that have been coming in to our office, and also your patience during this time as we actively work to obtain and share as much information as possible, both with insurers and ultimately to our clients. As we pose new questions and seek further clarification on policy wordings from your insurers, the response time is also being delayed given the nature of COVID-19 and the magnitude of positions being taken by insurers in conjunction with the sheer volume of queries that are being sent in. We are working around the clock to challenge policy wordings and precedent and current definitions across a range of products. And I'll touch on some of those today. We're also engaging with our legal partners, such as Gowling's, to provide timely content and value in moments of dire need. So I would encourage all of you to visit the CPA website and their distribution channels for that information. Because the situation is so fluid, unfortunately, I am unable to provide any definitive answers on coverage, given each case has its own circumstance, and these will ultimately play themselves out as claims come in and they arise. We will, however, provide our interpretation on a general basis to a variety of areas that physiotherapists and other health professions are seeking feedback. We will be providing a formal position statement on key coverage areas beginning tomorrow. But again, as new circumstances evolve, I would suggest putting forward any claims that may arise to your insurer, and we'll provide you with some information on how to do so. The insurers will assess each claim on its own merit, and we will continue to advocate on your behalf to the best of our ability.
Okay, Andrew?
Thanks, JP, and thank you to all of you for joining us this evening. As JP mentioned, I'm a partner at Gowling's in the Ottawa office, and we provide legal assistance to members of the CPA through your insurer. In light of the rapidly evolving nature of the situation, it's important that you make efforts to keep up to date on the latest developments. And by joining us tonight, you're doing that. What may have been acceptable this morning may not be acceptable later on this week. So it's important that you do keep up to date. We in our office, our team has been monitoring the websites of the various colleges and the associations across the country, and all of them have been providing guidance as to how to navigate the numerous issues that have arisen. In light of the time, though, this evening that we have, I'm only going to focus on the provision of physiotherapy services through electronic means, tele-rehabilitation. However, if you have any other questions about professional liability that do not get answered this evening, and I'm sure that you will, I encourage you strongly to reach out to our pro bono hotline. This is a hotline that's offered by Gowling's to members across the country. Our lawyers on our team are ready and able to assist you. And at the end of the session tonight, we'll give you the phone number that you can call if you have any other questions. The good news is that tele-rehabilitation is something that you may be able to offer to your clients in this ever-evolving time. I would invite you to seek out some of the resources that are available. The Canadian Alliance of Physiotherapy Regulators has guidelines that they issued in September of 2017 that provide some general assistance in terms of providing these services. The College of Physiotherapists in Ontario has added some helpful information to its website, which I would direct you to as well. If you are in the position or considering offering tele-rehabilitation as something to your clients, then there are things that you want to think about before you jump in. I appreciate that the current environment may lead you to want to rush out and start offering your services remotely in order to ensure your clients are receiving the services they need and to try and mitigate the impact it's having on your business. However, you need to ensure that if you are going to start offering these services, you are doing so in a way that does not run foul of the standards and guidelines applicable to you in your jurisdiction. You cannot assume that simply because the extraordinary nature of the situation that your regulator is going to be flexible or turn a blind eye if you do not follow the applicable standards and guidelines in doing this. In terms of what you should be thinking about if you are considering offering services remotely, I reviewed an excellent checklist today on the CPA website, the Canadian Physiotherapy Association website, that was prepared by Jennifer O'Neill that I would encourage you to review. Now, this list is not exhaustive, and there may be other things for you to consider once you've reviewed this list of questions. I'm just going to highlight a few in my opening here, and then I might be able to touch upon some of them with respect to the questions that have been posed. If you are considering tele-rehabilitation, then the first thing you need to be asking yourself is whether it is appropriate for your client. You have an accountability to make sure your decisions are always in the patient's best interest and aligned with your patient's expectations of care. For example, one of the things you should be asking is, are there physical, cognitive, or sensory deficits that may make the delivery of physiotherapy care unsafe or ineffective? What kinds of services does your client need? Is it simply a consultation? Is it education? Or is it an assessment and treatment plan that is going to be required? Are you able to provide these services in the absence of a hands-on in-person assessment? And obviously, services that don't require a hands-on assessment are easier to offer remotely than those that are. Do you have the skills and training to be able to provide remote physiotherapy? Importantly, is your client able to provide you with informed consent? Does the client understand that there are limitations to what you may be able to offer? Does the client have access to someone physically present at their location that can assist them if they need it? Do you have the necessary technology to carry out the services you want to offer? Does your client have the necessary technology? Is the technology you're using secure? Can you maintain privacy? Do you have a backup plan if you lose the connection or are otherwise unable to complete your session? Is the manner in which you're going to provide services compliant with the applicable privacy legislation in your jurisdiction? And is it in compliance with the guidelines from your college? And that's just a high level list of things you need to keep in mind. You need to be confident that the manner in which you provide these services is at the same level as if it would be if you were doing it face-to-face. If you believe that the level of service would be below what you can offer face-to-face, then you should ask yourself whether you should be doing it remotely. Hopefully, I'll be able to speak to some of these issues in more detail when we answer the questions that have been posed by members. Thank you.
Great. Thank you, Brian, and thank you, Andrew. That was very helpful. As I mentioned earlier, we'll be posting a few questions that we received from our members over the past few days. So Brian, I'll start with you. General question about what is business interruption coverage?
Great. Thanks, JP. This is obviously a very pertinent topic at present, and there's a lot of kind of communication in the media and flowing out from the insurance industry about business interruption coverage and how it relates to COVID-19. Business interruption coverage is typically purchased as part of a commercial property insurance policy. It's intended to protect the business against income loss and extra expenses sustained as a result of disruptions to their operations. And an example of that would be if there was restricted access or a requirement for relocation. Importantly, coverage must result from necessary interruption or from interference with business of the insured caused by direct physical loss or physical damage from an insured peril. And those are really key words that are essentially in every single policy, which is caused by direct physical loss or physical damage to the property by an insured peril. And one of the excluded perils is a pollution exclusion, which is becoming and will become a very pertinent and debated topic as it relates to COVID-19. In the Novex policy, Novex being the insurer under the CPA program, and they're a part of Intact Insurance Company, which is the largest insurance company in Canada. The definition of pollution exclusion is any solid, liquid, gaseous, or thermal irritant or contaminant, including odor, vapor, fumes, acid, chemicals, and waste. And like I said, without getting into too many technicalities on wording, this is going to be a heavily debated topic as COVID-19 expands. Note that this is a property policy, and so the intent of this is not a business income loss policy, it's a property policy. So physical damage to an insured property is required to trigger coverage. Again, damage must be caused by a peril, such as fire or windstorm. And a virus or disease is not typically an insured peril, and it is debatable whether a virus can cause physical damage. Now, with that said, as I've noted many times, this circumstance is very much unprecedented. Elements of the policy, such as civil authority restriction of access, is also attached to these main components of that policy. But again, they're also tied to physical damage. So an example would be it's unsafe to access a property due to a fire. And as quoted in the Globe and Mail yesterday, there was an article put out yesterday, coverage for pandemics under business interruption is not common in Canada. And the vast majority of business interruption policies do not offer this coverage. And where they do, it's very limited, essentially, and tough to claim against. However, this is a very evolving circumstance, and the government is in contact with Canadian insurers on these issues, given the application to so many affected people. Successful claims for business interruption and for loss of income for something like a pandemic or infection are very uncommon. But COVID is like nothing before, and it will change these definitions found in insurance policies. Our recommendation is very much to submit claims to the insurer if you feel that there is merit to do so, and allow them to interpret your particular circumstance and respond accordingly. We are working on your behalf with legal counsel and your association to challenge coverage interpretations that will come out. And there are already examples of these challenges being made, which will have a potential significant impact and precedent. News, for example, there was news that broke today of a suit filed in Louisiana against an insurer, and the suit argues that COVID-19 pandemic is exacerbated by the fact that it's a fatal virus, and it affects and stays on the surface of objects or materials for up to 28 days. And the argument here is that because the virus is relatively long lasting, there is direct physical loss, and as a result, there is a need for remediation to be required. So one can argue that there is physical loss. And this is just one example of many situations that are very much likely to arise out of debate on this particular coverage. So we will continue to monitor this situation and questions and claims that come forward. Tomorrow there will be some statements that will be coming out surrounding coverage, and as outlined, it's a very significant topic at present. And the premise of this coverage under a property policy is going to come out more and more. But JP, that's essentially what this type of policy is, what it's intended for, and the potential ramifications that are likely to occur as it relates to the circumstance that we're in today.
Great, thanks, Brian. I'm going to throw a question over to Andrew. Andrew, one of the questions we have is, if I am providing services remotely, are there additional steps that I need to take in order to ensure that I have consent from my client?
Okay, thanks, JP. Yeah, there are additional steps. In addition to what you normally would review with your client when obtaining consent, you should also be taking or expanding that conversation with your client to include in the risk discussion the possible insufficiencies related to video conferencing, including misunderstandings due to lack of visual clues, technology failure, bad connections, sort of thing. So that needs to be front and center of any discussion. Obviously, with respect to benefits, you want to talk about the advantages that it offers. It's convenient. It's comfortable for the client in most instances. It may lead to them not having to travel, etc. So you've got to go through that as well. You do need to discuss the reasonable alternative service options if they are available. And I appreciate in this environment there may not be many other service options, but you do need to consider what else might be available to your client. And then finally, you want to talk about the privacy limitations that accompany tele-rehabilitation. So the big one being the possibility of interception of communications, depending on what medium you're using. Obviously, you are using a third-party platform to provide these services, and you can get all the assurances you want from the provider, but there's always that possibility of interception or of interruption. So the client needs to be aware of that. Hopefully in this environment, they are aware of that. Ideally, you're going to have all this set out in a written consent that the client signs, and you can have that done by having the client sign it and scan it and return it to you. Obviously, if you're not doing so in person, but best practice is to have all of that set out in writing so that you have something to go back to if a problem does arise.
Thank you. Sorry about that, guys. I had it on mute there for a second. Brian, next question. Does my professional liability insurance policy follow me if I'm to work outside of my clinic and provide other means of care such as telemedicine?
Yeah, the professional liability policy, the insurer of that policy is QBE from Lloyd's of London. So it is a different policy when compared to perhaps a property policy that members, some members purchase who may own a clinic or operate in private practice. The professional liability policy has no restriction in terms of your place of work, as long as you're working within the policy coverage territory in Canada. And so there is no limitations on coverage for telemedicine or things of that sort. We appreciate that there will be potentially very much a changing dynamic in terms of how physiotherapists render care. And so as long as you are operating within scope of practice, your policy does cover you in those circumstances, and that includes telehealth and telemedicine.
Great. Andrew, next question from our members is, am I able to provide services remotely if my client is located in another province or other country?
Thanks, JP. And I guess that follows the question there for Brian. So the short answer is yes, you can provide services to a client in another province or country, but there are things you need to be aware of. Just dealing first within Canada, again, referring back to the Canadian Alliance of Physiotherapy Regulators, they issued guidance on this issue in 2017. The 10 provinces have a memorandum of understanding with respect to the provision of physiotherapy where the client's in a different province. Essentially, what it means is that you need to have your certificate of registration not only in the jurisdiction where you reside, but the jurisdiction where the client is located. Now, I know the memorandum does state that they are trying, the understanding is that they are making it easier for members to be able to get their certificate in the second jurisdiction, but you still need to have a valid certificate of registration in both jurisdictions in order to provide that those services. If you are dealing with a member or a client in another country, then the advice is to follow up with the regulatory body in that jurisdiction to find out what, if anything, you need to have in place in order to provide services. And the reason you need to do that, and applies to Canada as well, is that if your client is in another jurisdiction and wishes to raise a concern about the services provided or has any questions, they're likely going to go to the regulator in that jurisdiction, not where the member is located. And therefore, the regulator needs to have an understanding or an idea of who is providing services and have some jurisdiction over that. So it is a bit onerous, but it's something which the regulators all recognize is happening, and they're trying to make it easier or more convenient for members to do that. But you do need to be certified in both jurisdictions.
Great. Brian, next question from our members is, if I infect a patient without knowing I have the virus while rendering clinical care, and I am sued, will my liability insurance protect me?
Well, thanks, JP. Again, the caveat being the situation would very much depend on the unique circumstances in that scenario. But this is an interesting topic at present because today we were made aware of a few health professions releasing information out to their members advising that the professional liability coverage may not cover them or will not cover them for these circumstances. That is, we have spoken with a multitude of insurers, including the insurer under this program, We certainly do not take that blanket position at all, and that has been agreed by QBE, your insurer. And the reason for that, there is no exclusion in the policy related to transmission of disease. There was, at some point in time in relation to HIV, those are kind of gone. Then there were some after SARS, that some markets put in place. Those have since been removed, and under the CPA policy, that exclusion is not in place. However, for a claim to be defended and successfully covered, there needs to be or a damage rewarded. There needs to be proof of negligence on the part of the practitioner. And perhaps a duty of care, a standard duty of care was not provided, and as a result of that, there has been damage, such as transmission of the virus. I think what makes this particularly difficult is identifying the origin of transmission. How do you prove that it happened in a clinic, and all of those types of circumstances? But to reiterate, there is no exclusionary language in the policy around transmission. So if there are any claims or circumstances that arise, please notify us immediately, because it is something that we would argue to have the policy defend you for, given the policy conditions in place.
Okay, great. Andrew, next question. What happens if the call drops or I lose the video conferencing connection when providing services?
Thanks, JP. This is always a possibility, and in going through your consent discussion, this is one of the things you need to address with your client. The advice is and the guidelines actually from the Association of Physiotherapy Regulators is that you need to have agreed in advance to an alternative communication procedure in the event of a technology failure. So if your video conferencing drops, then you need to be able to contact the member or the client by phone. There needs to be some way, some plan in place for you to be able to get back in touch with them. At the same time, you also need to have a discussion about the procedure to be followed in an emergency. So you're on a conference with your client, and something happens to your client while you're talking to them. You need to have something in place to have them follow the contact info for a qualified healthcare provider who can provide local assistance, local emergency telephone numbers, and the client's emergency contact. So you need to be prepared for all potential possibilities, so that if something happens and you are not physically present, there is a system in place to allow for the appropriate care to be provided.
Perfect. Great. Brian, next question. If my earnings are negatively impacted by this and I am required to stop working, do I have insurance to cover this loss of income under my professional liability policy?
Thanks, JP. This is a question that we have been receiving a fairly significant volume of, because there is an endorsement on the professional liability policy for loss of earnings, and it requires what I believe is a $750 a day reimbursement for loss of earnings. Unfortunately, that is not coverage associated with the circumstance or your inability to work. Instead, that loss of earnings provision is if you have a claim that's been made against you, and it's for loss income that is derived while you are defending that claim. So perhaps you're attending a college investigation, disciplinary hearing, or a court or a meeting with legal, but it is not loss of income as a result of cessation of practice or inability to work.
Okay. Andrew, next question for you is, do I need to record the video conferences?
So the short answer is no. There's no specific requirement that you record a session. However, you still need to have a hard copy of all communications of a material nature, and notes regarding contacts of a material nature. So you need to treat the session as you would if it was an in-person session. You've got your notes, etc. However, there's lots of reasons why you would want to record the session and keep the data. And if you do want to do that, then obviously you need specific consent from your client to do that, not only to record it, but to store it, and the client understands the means in which you are storing it. And you need to make sure that any recordings you do have are secure and kept confidential, and that the client is aware of that policy. So no requirement to do it, but if you're going to do it, you need to take extra steps to ensure you have consent and that the data is maintained in a safe and secure manner.
Good to know. Brian, the next question is, I was working in a clinic and now I'm working from home and am seeing patients at an alternative site. Do I need CGL insurance?
Yeah, this is this question is creating quite a bit of confusion and volume around this issue, and we are working with the insurer Novex under the CGL policy. CGL being general liability, so it's like slip and fall insurance. This is not property insurance. This is not your professional liability insurance, but instead, insurance that a business or independent sole practitioner may have. If slip and fall, if someone is attending your clinic and they fall on the way into the clinic. If you have been working as a physiotherapist within a clinic and perhaps getting billed, overhead to work within that clinic, and as a result of this, you are now working from home and working independently of that clinic, our recommendation is that you should purchase general liability. You can purchase that coverage online. It's fairly cost effective, and it's prorated because that clinic's insurance may not follow you directly into that circumstance. If you continue to bill under that clinic's name, so you're still working on behalf of that clinic as an employee of that clinic or a contractor of that clinic, and still paying overhead into that clinic, there may not be a requirement for you to buy your own general liability, and that's our recommendation to the insurer and what we think is appropriate. You must ensure, obviously, that the conditions in which you're working meet the standard criteria set forth by your college and so on. However, there is no requirement in that circumstance potentially to buy additional insurance. Our suggestion is that this should be a question that you can pose to our staff, to send an email and inquire about it. We are seeking to get a general response and kind of a position statement on this issue from the insurer that will enable an easy following of insurance given the changing dynamic and circumstances that are in place.
Great. Andrew, our next question we have from a member is, I want to communicate with my clients via email or social media to provide updates and to offer another line of communication that my clients can use. Are there any risks I should be aware of in doing so?
Yeah, that's I could go on. I could do a whole session just on email and social media. But in currently, I know there are members in many of the different healthcare disciplines that are looking for ways to be able to communicate with their clients other than face to face. When we're dealing with email and social media, privacy and confidentiality are the paramount concerns. Let's talk about social media, for example, as the first item. Any information that you're going to put on social media needs to be general information. It cannot be client specific. It's good to talk about hours of operation, etc. But it needs to stay general. If you're using email, then again, you need to be careful with what you put in email. Email is typically not secure. So again, if you want to communicate general information to your clients via email about operating hours or different policies that you put in place to deal with the current situation, then that's acceptable. If you have clients that want to communicate with you directly about their issues, then you need to make sure that your email is secure. If you look at the information from the Privacy Commissioner in Ontario, for example, you should be using email that's encrypted so that if it is intercepted, that it can't, or it's going to be harder for somebody to see what's there. As soon as you're dealing with personal health information from a client, you need to be extra careful that it's transmitted in a way that's safe and secure. So our general advice is if you're communicating by these means, it should be general information only. And if a client wants to speak to you directly, it's probably better to try and do it by telephone than by email. But if you do need to do it by email, then make sure that you have the appropriate security measures in place to ensure that the information is protected.
Thanks, Andrew. Brian, the next question is, if my staff or volunteers become infected while carrying out their work on my business organization's behalf and they sue me, will my EPL or other policy respond?
The EPL policy, which is employment practice liability, is a policy that's offered to physiotherapy clinic owners or business owners, and essentially that is coverage that provides protection for things like allegations of wrongful dismissal, for failure to promote, for retaliatory treatment. So if an employer were to say, hey, if you don't come into work, you're going to be fired, things like that. There's a potential avenue there for clinics if they have their staff taking action against them for coverage to be afforded. So that's kind of one potential avenue in that circumstance. There is potential general liability channels for coverage in this circumstance, but the feeling in the insurance industry is that pollution exclusions that are in general liability policies are likely to be argued by insurers as a channel to deny coverage in these circumstances. Kind of same items as I have identified before. If in the event that you have a notice or a statement of claim or any type of allegation of this nature brought against you, would be to either formally submit a claim if there's an action, contact the pro bono line, or contact us to obtain some resource and clarification in the event of that circumstance. This is yet another one that is really evolving, and it's kind of in new territory that we expect a lot of literature to be coming out of the industry very shortly on different positions being taken by the insurance market that may be challenged through claims, and some upheld and some not. So I guess the kind of point to be made here is there are some potential remedies through insurance to transfer this risk, but it is a very gray one. So if these circumstances do arise, to communicate with through the pro bono line or to us is our recommended approach at this time.
Great, thanks. Unfortunately, we've actually run over time, but there's been a lot of good questions, and thank you very much for all for clarifying a lot of those positions. So we are going to bring the session to a close. I do want to add that if there are any additional questions that you want to ask about this topic, feel free to email our CPA membership team at information@physiotherapy.ca. and we will use them to inform our, our Friday, March 20th webinar at 2 p.m. Eastern on the same topic. If you have any questions for BMS, please email cpa.insurance@bmsgroup.com. And if you have any questions for Gowling, please call their hotline at 1-888-943-0953. As we mentioned, this will be recorded. You can go back and listen to this and get all the information again if you need to. Now, if you're interested in joining our next webinar in the COVID-19 series, it's actually happening tomorrow, Wednesday, March 17th at 7:30 p.m. Eastern Time, to hear Kareem Medji and Daryl Yardley talk about COVID-19 and your practice. You can register via Zoom by visiting our website or stream on Facebook Live. As we end this off, I'd like to thank Brian and Andrew for being available today. I know they are very busy with taking questions and working with not just physiotherapy, but other professions. So thanks to both of you for taking the time this evening. I hope for those of you who are on and listening, you found today valuable and you can make this information useful during these very trying times. So thank you, and we'll hopefully see you again in the next session.